Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Welcome to the Fourth Circuit this morning. We'll be happy to hear first case, United States versus Linville, number 214559. Counsel.
Good morning, and if it pleases the court, I'm Kathleen Gleason, and I represent the appellant Eugene Linville in this case. Your Honors, the question that Mr. Linville presents is whether his exercise of his right against self-incrimination under the Fifth Amendment is self-executing because the questioning by the probation officer presents his refusal to answer the question by the probation officer presents a substantial penalty. And I want to focus, Your Honors, on a question that I think has come up in some of the cases is, and the district court raises as well, is the questioning by the officer coercive? And I think that turns the standard on its head. I think the question that the court should be looking at is the penalty sufficiently coercive so that a person does not feel free to answer, not whether what the probation officer is doing at that moment, but what is the penalty?
Is that, counsel, is that analysis, for right now, putting aside the merits of it, is that largely foreclosed by precedent?
Your Honor, I do not think that it is. The question that the court in Minnesota versus Murphy asked is whether by implication or expressly the government has presented a penalty that's sufficient. In this case, Your Honor, regarding a probationer, the government is the judicial branch, which includes at the outset in a case like this where his conviction was by plea, includes during the Rule 11 colloquy, the district court admonishing and advising a person. And this is, Your Honor, an example of that is at 105 of the joint appendix where he pled to the new case, where the court admonishes a person, you must, well, I can read exactly what the court said in that case.
This is the new case? So this is after the events we're talking about?
And it's really an example and not necessarily evidence.
Do we have record evidence in this case that was said in the first hearing? I mean, it's hard to consider as evidence something that happened after the fact.
Yes, Your Honor, and I do not mean to be presenting new evidence, but it is part of the Rule 11 colloquy. It's one of the requirements is that the person be advised of all of the penalties, which includes supervision, and advised that if you violate supervision, you can be returned to prison.
So can I ask you, so you mentioned Minnesota versus Murphy, and it said when you're advised expressly or by implication. And one question I have is, when do you contend that he was advised that? Because as I understand it, your client did not testify at this hearing, right?
That's correct.
So there's no evidence in the record about what the probation officer did or did not say to him before he said this.
That's correct.
And so for example, I mean, let me give you an easy case. If the probation, well, maybe an easy case. If there was testimony in the record credited by the district court, the probation officer said, I'm about to ask you a question, keeping in mind that you have an obligation to answer my questions. And if you don't answer my questions, you're going back to jail. That to me would be a much easier case than the one we have here.
Yes.
But there's no evidence that happened because your client didn't testify. So there's no evidence in the record the probation officer said that. So then is the answer your view that it's the condition itself? Like when is it communicated to him in your view that unless he answers, he's going back to prison?
Your Honor, it's communicated in the judgment, which includes the conditions of supervision.
And we constructively assume that in that moment, your client was aware of what was said in the judgment, that's the idea?
Your Honor, I think that we can't read out the implicit part of what Minnesota versus Murphy raised. It was express or implicit, and is implicit that a person who is on supervision, a person on supervision knows because of the judgment, because of the penalty, that they can be returned to prison for violating a conviction.
Okay, so
and that's just the law.
Okay, but that may be true, but the problem for me then is if we're dealing with constructive knowledge rather than testimony that the probation officer actually said to him, I don't know what we do with the application note to 5D 1.3C4 of the guidelines that addresses this exact issue and says refusing to answer questions is not a ground for revoking your supervised release.
Your Honor, that section of the guidelines was an amendment that was put into place in 2015, which was after his 2013 judgment, which is what he's being revoked on. So the guidelines that applied then, the actual language of the standard condition has changed. Originally under Mr. Linville's, it was that you should answer all inquiries of the probation officer truthfully. Now the condition since 2015 is that you should answer all answers, or that you should answer all questions. And I don't think that that's relevant. But Your Honor, that change to the guidelines happened after Mr. Linville's conviction and— But
before the violation here.
But before the violation hearing, but it was not one of the conditions. The condition actually changed. So the condition Mr. Linville was under was to answer all inquiries. And the guidelines that he was under at that point, which is the conditions he was under, did not include that section. So he did not have any sort of notice that it could not be used against
But to follow up on Judge Hyten's mention of that application, it looks like whether there are cases in our circuit and all over, and none of them are just perfect, but they all kind of relate to things. And the situations where it seems like courts have adopted your argument are where the law in question in the Ninth Circuit case, Oregon law said that if you invoke the Fifth, you are violating your probation. Or in the 11th Circuit, McCathan or whatever, I may get that name wrong, where they had where the defendant testified very similar to what Judge Hyten's described. Absent that, when the law is that, look, you got a constitutional right to invoke the Fifth Amendment, you're either under state law in New York or federal law in other places. No one seems to kind of be going with that argument.
Well, Your Honor, and that's correct. The cases that are out there are much clearer. What I would ask the court to consider is that in that suggestion that we should actually look at whether the penalty is coercive, not whether the probation officer's questioning was coercive. I'd ask the court to look at this situation, the other self-executing outside of the text.
Is that right? I mean, so you keep saying like, let's ignore the probation officer, but I took Judge Hyten's question earlier to be, let me just ask as a hypothetical, maybe instead. Imagine the law expressly, maybe as it does here, but imagine expressly said that you cannot be imprisoned for invoking your Fifth Amendment right. But the guy shows up and the probation officer says, if you invoke your Fifth Amendment right, you're going to go to prison. I'm going to send you to jail. And the guy answers, right? We might say in that scenario, even if the law doesn't impose a penalty, right, that the probation officer's statement might suffice to create such a penalty situation, right?
Well, Your Honor,
I mean, I guess you want to say it's just about the law, but that doesn't seem right. I mean, it seems like to me what we're trying to determine is sort of, whether a reasonable person in the circumstances they've got believed that they were going to go to the pokey if they invoked the Fifth.
And I think that's right, Your Honor. And I do want to separate out because this is such an entangled question. There's nothing that I am raising that says, probation officer, you can't ask this question. He can ask the question. Mr. Linville can answer it and he can get revoked. The question is the new criminal prosecution. And in that case, I think, Your Honor, that the question is the circumstances. Like a custodial issue.
Why is that? Help me understand. I want to make sure I understand your position on that. Why is it that it can be used to revoke him, but not in a new prosecution, if it's a Fifth Amendment violation? Because
that's the heart of the Fifth Amendment, Your Honor. The Fifth Amendment says that this cannot be used against you in a criminal proceeding. And this court in U.S. v. Ka has found in a published opinion that a supervised release violation hearing is a separate animal and is not a criminal proceeding. So under the current circuit precedent, he can be revoked. In fact, he was
Just like
revoked for
civil
that.
proceedings or competency hearings or all the other situations where you can't.
That's correct. And the Fifth Amendment says criminal proceeding. And that's why I think the court should look at the other situation where it is self-executing, which is a custodial situation where we don't say, hey, your Fifth Amendment right is not self-executing unless the officer says, hey, you're not free to leave. We look at what.
But I'm not sure that, with all respect, I'm not sure that situation helps you, because the analogy I'd want to be here is, so we know the officers asked some questions, but because neither the defendant nor the officers testified, we don't actually know anything about what they said. We don't know about the setting where it occurred. We don't know how long he was there. All we know is they asked him some questions and he answered. If you brought a Miranda claim in that situation, we'd say there's been a failure to prove you were in custody for Miranda purposes.
Yes, that I agree with that, Your Honor. But in that case, in a custodial situation, there's no law that says you've got a judgment. This is your sentence, as the court has found that the supervision is part of that sentence. And if you violate your supervision, you can go to prison. And there is no greater penalty than sending someone to prison. And I think that that's where the implicit comes, because of course I can't stand here and say that I'm relying on the express.
If you had this same, or you had a clearer judgment, but the probation officer began by saying, listen, if you answer, you got to be truthful, but you can invoke the Fifth if you'd like. It wouldn't matter what the judgment would say, right? I mean, this is the sort of inverse of the hypothetical I gave before, that the probation officer could go either way. He could say, if you invoke the Fifth, I'm gonna send you to jail. But he could also say, if you do invoke the Fifth, I will most certainly not send you to jail.
Well, Your Honor, I don't think that the probation officer has that leeway, because the judgment is a judgment of the district court. The conditions of supervision are the conditions imposed by the court, and the probation officer has an obligation to.
That's fair. I mean, technically, the probation officer can't say, I'm going to send you to jail if you invoke the Fifth. But if he said it, we would take it as relevant to what a reasonable person would believe.
Absolutely.
Right? He might not be able to say you're not going to go to jail. In fact, I think he could say that, because that happens to be true in the federal system, that he can't go to jail for invoking the Fifth. And so if he said what the law is, that would obviously inform what a reasonable person would believe, no?
Well, Your Honor, he could go to jail for invoking the Fifth, because one of the conditions of his supervision is to answer all inquiries truthfully.
How can he do that with the application note?
I'm sorry?
With the application note?
Because his conditions precede the application note, Your Honor.
Because inquiry and question are different.
And because the application note didn't exist at the time, and that's not.
Well, except that the court deciding whether to revoke him is after the note. And I've looked at the language of the note. The note doesn't purport to change what the rule is. The language the note uses is to clarify. I mean, pretty obviously in response to the Ninth Circuit's decision, the note says this is to clarify that if you invoke the Fifth, you cannot be violated purely for that. Is there any indication? I mean, if the shoe were sort of on the other foot, if you were representing a client who was in fact, you would say that under that note, the district court can't send him back to jail. And regardless of whether it existed at the time of the judgment, you would say that note says you can't send him back to jail, right?
I would, Your Honor. And I would say that note is perhaps not binding on the district court, but certainly advisory. I think the question, though, is separate as far as it applies to the probationer or the person under supervision. He is under the supervision that he received in 2013. I think to impute to him the knowledge that the guidelines have changed and that there is this note in the guidelines is simply a step too far to remove the implicit penalty.
This just returns me, but the whole problem is this is all implicit because your client never testified, and we're all constructing the hypothetical knowledge of a hypothetical individual. And it seems to me that you want us to impute some hypothetical knowledge to him, but not all the hypothetical knowledge to him. And I don't really see how we can do that.
Well, Your Honor, I would argue that the knowledge isn't hypothetical, that the judgment is the judgment. He is under supervision. He understands that. Well, Your Honor, I shouldn't say he understands, because we don't know.
We don't know. Can I ask you, you're running out of time. Can I ask you about the inevitable discovery? So first question, I will say I'm genuinely not sure if I think the district court actually made a holding about inevitable discovery, but do you agree that if the district court made a holding on inevitable discovery, you have forfeited any challenge to that by not briefing it on appeal?
Your Honor, I did not brief it because the court did not reach that, and I don't think it's properly before this court. I think the district court quite explicitly did not reach that in his holding, and I don't raise it, and I don't think that it's
okay. I just want to clarify. So your only argument is the district court did not reach it. Not
that's exactly right, Your Honor. And if this court should find for my client, then certainly it would be returned to the district court to consider inevitable discovery, among other things. If the court has no other questions, I yield. Thank you.
Counsel, we're happy to hear from you.
Good morning. May it please the court. I'm Julie Niemeyer for the government. The question we're presented with here is essentially whether any routine interview between a probation officer and a defendant on supervised release is inherently coercive. That's not what Minnesota versus Murphy tells us. The district court properly recognized that in denying the motion to suppress. The evidence here shows that Mr. Linville's statements to his probation officer were voluntary. They were not compelled. The requirement to appear and answer questions of the probation officer is...
Do you take Judge Hyden's point? I mean, you say the evidence shows they were voluntary. I take Judge Hyden's point to disagree with you, to say there's just not evidence of whether they were voluntary. And that means you win, right? But there's a little bit of a difference there. Does that matter to you? Right? I mean, because we don't know what the probation officer said. The probation officer could have said, you know, I've got this taser. If you don't answer my question, I'm going to tase you and send you to prison. I mean, you know, we don't really think that's what happened, but we don't actually know. Does that matter?
Well, Your Honor, it does matter because in this case, we have testimony from the probation officer. We have explicit testimony that he asked the question of Mr. Linville and he didn't say anything else. He didn't threaten Mr. Linville. He didn't tell him, you have to answer truthfully. He didn't tell him, if you don't answer, you might be subject to revocation. So yes, it is a negative situation in terms of there is an absence of evidence, but he testified that he didn't say those things.
And that's uncontroverted effectively because the defendant didn't testify.
Correct, Your Honor. And the district court made a finding that the probation officer was credible. He found the probation officer's testimony very credible. So in this case, yes, there is an absence of that evidence, but what we take from that is there is no objective showing of coercion. And in a Fifth Amendment situation, if you don't assert the right, then we are looking at, well, what circumstances may have made the defendant feel coerced. So in the absence of any objective evidence of those circumstances, testimony from the probation officer, the absence of any other evidence from another source, we have to look at whether there was a belief by the defendant and whether that belief was reasonable. And here we see that there simply wouldn't have been a reasonable basis for that belief.
You say there has to be both a subjective and an objective. Why does...
Oh, no, Your Honor. No, let me clarify, Your Honor. In the absence of objective evidence that coercion was present, then the next step is to see if, even in the absence of such evidence, the defendant may have felt coerced. And there was testimony, there was evidence of that in these other cases where we've seen a finding that there was a Fifth Amendment violation.
Hasn't the Supreme Court spent the better part of 4 decades purging subjective concepts from Fourth and Fifth Amendment analysis? Don't we say, haven't they said over and over again, what's in someone's heart doesn't control the Fourth or Fifth Amendment? Because if you did that, you could always allege that someone had something bad in their heart, and then it means you could never resolve any issue without a full-blown, right? I mean, absolutely,
Your Honor. And this wouldn't be a subjective belief that would create a violation. This would simply be, we're examining the record to see if perhaps there were circumstances that would have been reasonable. And in Minnesota versus Murphy does lay out the reasonableness standard. That belief must be reasonable.
The defendant's purely idiosyncratic belief that he has to answer can't create a Fifth Amendment violation.
Correct, Your Honor. Absolutely.
Can I take you afield for just a second? And I don't mean to put you in the position of criticizing the Supreme Court, but I am. So tell me why we think of the Fourth and Fifth Amendments differently in this context. We often think in supervision context that that the government can require a defendant to waive his Fourth Amendment rights, at least in some contexts, or at least to some degrees. Well, why do we think the Fifth Amendment is different? I mean, Murphy seems to tell us that the Fifth Amendment is different, and that the government can't say we'll revoke you if you refuse to answer, but they can say we'll revoke you if you refuse to allow us in your house or whatever it might be. Do you have an insight as to why we think of those two differently?
Your Honor, I couldn't pretend to any insights on
That's
that.
fine. That's why I'm not,
subject,
I'm not trying to get you to speculate. I just thought you think about these questions a lot, and I just thought I'd get your take on it.
Well, I think it's very important in the supervised release context to consider the policy considerations. We have a program of supervised release that has to be administered by the probation office. And part of that program requires answers to questions. The probation officer cannot do his or her job without being able to get answers to his or her questions, to see how the defendant is doing on supervised release. So in that context, it is a sensitive area, and that's why the application note and the other aspects of the guidelines go into great detail about what the probation officer's duties are and what the constitutional parameters are on the exercise of those duties and those responsibilities.
So let me preface this by saying that the most mortifying experience I ever had as a lawyer was when I realized that a brief that I filed had failed to cite a highly relevant commentary on one of the federal rules of evidence, which was totally my fault. So I totally understand how I was a bit surprised to discover that what strikes me as perhaps one of the most important authorities in this entire case, an application note to the sentencing guidelines, I only discovered for the first time when I read a decision that's cited in your brief, but the application note itself is never cited in your brief. Did the government consciously decide not to cite that application note? And is there something I'm missing?
Your Honor, that issue wasn't briefed in the response brief. That's correct, but it was brought up in Mr. Linville's reply brief.
Sure, but surely the government is not unaware of an application note that's really, really favorable to the government and really, really bad for the defendant.
Yes, Your Honor.
Was it just over? I mean, if the answer is it's just overlooked, that's fine. But I guess I want to make sure that it's not that the government doesn't think, as you mentioned, it was brought up in his reply brief. I want to make sure that you're not going to tell me that you actually think it has nothing to do with this case for some reason.
Absolutely not, Your Honor. And I think that was simply an oversight in the response brief. The government did discuss the McCathan case, which of course goes into great detail about the application note.
And can I ask you a question I asked your colleague on the other side? Do you understand the district court to have reached a holding on inevitable discovery? Candidly, when I read the district court's opinion, I'm really confused about whether it reached a holding on inevitable discovery. And could you try to illuminate that for me?
I understand. Yes, Your Honor. If Your Honor would look at JA 71, there are some findings made which are not an explicit finding that inevitable discovery would apply, but there are factual findings there. I may just find that page here. What the court does there is make a finding that what Mr. Long testified to, that he found credible. He says the comment of very likely from Mr. Long, he says he had 18 years as a probation officer. He says, I can't say with 100% certainty because something might have come up that might have.
Yeah, that's where I got confused. The district court seemed to have got wrapped around the axle about the word inevitable, that in order to find inevitable discovery, it would have to be metaphysically certain that it would have happened, despite the fact that I think the doctrine is it has to be more likely than not metaphysically certain that it would have happened.
Right, Your Honor. But he does say, I think he's speaking in the probation officer's voice when the court says, I'm going to conduct that search and get that contraband unless something stops me. And the court wasn't making that explicit finding because the court didn't need to, because the court found that there was no Fifth Amendment violation. But I think at that point, the court is kind of laying the groundwork for saying, these are the facts that I'm finding. I'm finding that this probation officer's testimony was very credible. And I find that he's going to go and get that contraband unless something stopped him. So
but it doesn't seem quite like a whole, because I mean, if the district court had said, I find there was no Fifth Amendment violation, and I find that even if there was, inevitable discovery applied, then the defendant's failure to brief inevitable discovery might just resolve this whole appeal. But I mean, I agree with you. I suspect that if we were to agree with the defendant and if we were to send it back, there is a very good chance the district court judge would find that inevitable discovery applies. But I'm not quite sure that the court has actually gotten there yet. Is that a fair description of the record?
Well, Your Honor, I do think the record has sufficient findings in it for the court to make that determination. So the court.
But your point, I take you're agreeing with Judge Heitens, and since we would have to basically affirm an alternative ground, a ground that was not definitively decided by.
That's correct, Your Honor. Yeah. That's correct. And
but you think, in effect, your argument is the factual findings that were made effectively compel the result, even though the result was not reached below.
That's correct, Your Honor. I think the court's colloquy established that the evidence clearly could have been discovered. Mr. Linville was under that condition of a warrantless search upon reasonable suspicion. Even at the point after the polygraph had concluded and before any other questions had been asked of the defendant, at that point, reasonable suspicion existed. The probation officer knew that deception had been shown on the polygraph. He knew that Mr. Linville had answered every other time he'd met with him, no, I don't possess pornography. And so at that point, even at just the point of the polygraph, the probation officer knew that there was deception and that the defendant had been dishonest with him in the past. So the reasonable suspicion already existed at that point. And then we just have to go to the question of whether he would have gone and gotten that evidence. And I think the record shows that he would have done so. He testified he had done warrantless searches of child exploitation defendants in the past, that he would have done a thorough search of all the areas of the residence. He would have gone to the basement. He would have seized external storage devices. And all of that would have proceeded from that reasonable suspicion. And again, the district court found his testimony very credible. So I think those findings in their totality regarding whether he could have done that search under the warrantless search provision and whether he actually would have done that, I think those findings are there. So
unless you have something further.
If no further questions, Your Honor.
Great.
Then the government rests on its brief. Thank you.
Happy to hear from you, counsel.
Thank you, Your Honor. And I do want to address one question that Judge Richardson had, and I think it is one of the issues in this case that can be difficult to keep untangled, and that was whether the probation officer can say, if you don't answer, I'm going to revoke your supervision. The officer can say that. The officer can revoke the supervision as far as the question before the court now. The question isn't whether a person can have their supervision revoked, even if their rights are violated or whatever the probation officer said to them about their rights.
But if a judge did that, if a district judge did that, and it came up on appeal, the defense lawyer would say, see this application note? Right? It's an abuse of discretion to do that.
Yes, Your Honor.
Right. And so, I mean, the probation officer, in theory, can say lots of things. The question is, can they truthfully say it? And it strikes me as really hard to imagine that an officer could truthfully say, if you invoke your Fifth Amendment right, you will be put back in prison. Like that seems to be a false statement. Could a probation officer say it? Sure. I mean, anybody could say it. My point is you can't truthfully say it.
And the court is correct. If that were my case, I would certainly raise that issue. I do want to make sure that we're untangling, though, that I'm not raising the question about whether the probation officer could revoke Mr. Linville's, or at least submit a petition, because the probation officer doesn't have that authority, but could ask the court to revoke his supervision, even if the answer is given in violation of his Fifth Amendment right.
I mean, but the point is the probation officer could say, I want to put him in stocks in the town square, right? But like we know a district judge is not going to do that, right? And we similarly know that if he invokes the Fifth, the district judge is not going to put him in prison. I mean, that we know that, like, that to me is a separate question. I mean, you could have a false but reasonable impression, but there's no real argument here that he could have a truthful belief that he's going to be put in prison for invoking his Fifth Amendment right.
That's right. And that's, Your Honor, why I'm asking the court to consider an objective standard. And I will reference Minnesota versus Murphy, where the court said, we're not making a determination of whether or not this is subjective or objective. They explicitly said that. And that this really should be an objective inquiry. And the objective inquiry is whether someone in Mr. Linville's position, where he's under conditions of supervision, where a violation of those conditions can lead to further imprisonment.
Do you have a view on the question I answered your counsel? Why from sort of a first principles matter, we treat the Fifth Amendment differently than the Fourth Amendment in this context, that we're more protective of the Fifth Amendment here than we are of lots of other rights that we say can be waived?
Your Honor, I think that, I mean, it really just sort of goes to the question of the framers at that point. But it seems to me, Your Honor.
Well, but the framers didn't find the fifth wasn't more important than the fourth. I mean, maybe they're more important than the third. We can talk about that. But the fourth and fifth sort of seem equally sort of important, right? I mean, they're not in order in some sense, right? Like,
I think that the sanctity of sort of the person and the threat of imprisonment of the person is so critical versus the sanctity of a person's home.
But the sanctity of the home is what really put him back in the prison, right? I mean, it's like the things that were in his home. I mean, that's what really put him back.
What really?
You see what I'm saying?
What really put him back was saying, "I have my dad's Playboys." Yeah. I mean, that alone is grounds for revocation, and then saying, "And I've got child pornography." It wasn't the going to the home and giving him the contraband; it was the statements that he said that. And I think the idea that the force of the government in whatever law enforcement, whatever guise it is.
Is that true? I mean, could he be prosecuted based on an uncorroborated confession?
He could have his supervision revoked, certainly.
But couldn't be prosecuted for it. A wholly uncorroborated confession.
Prosecution would be successful, I think, is a separate question if that's the basis of going to the grand jury. Certainly, Your Honor. But that, I think, goes into the question of the inevitable discovery, where if he had not volunteered that he had child pornography, I think it becomes a separate question. And that's where we would be if we're getting to inevitable discovery, is that statement disappears. And I see that my time is up, Your Honors, and if there are no other questions, I certainly yield.
Thank you, counsel. As you probably know, we would love to follow our longstanding tradition and come down and greet you in person. Unfortunately, we continue to abide by restrictions that prohibit us, but we thank you from here, and we hope we see you back again so we can do it in person. We'll stay on the bench, but we'll take just a minute while the staff gets us ready for the next case, 21-2207.
and associated benefits, the related medical care around surrounding.
And
that.
so I understand that the loss of the procedure, and then I also understand separately there's sort of an unjust enrichment theory that is sort of an injury of sorts. But is there anything else? Are those the two different pieces of this? There's sort of an unjust enrichment from keeping the money that would have been spent on the surgery, and then there's like a loss theory that is the loss of the procedure. Is there anything else, or are those the two sort of injuries, remedies that you're seeking to address?
No, that's exactly right, Your Honor. Those are the two, and those are the two discussed in Amara, and the two really in depth discussed in Peters. The unjust.
So if I could, before you get into those two things, on the unjust enrichment theory, I mean, looking at your complaint, I mean, I think in the prayer for relief, maybe, you know, you have a one paragraph that lists a few equitable theories. But when I read your allegations, everything you say you're seeking equitably is benefits. It's not to prevent the unjust enrichment. It's to obtain what you claim are benefits. If there's something other than that prayer for relief, you know, if you could point me to that, and feel free to do it later in rebuttal. I don't want to distract you too much, but no, I didn't see that in the complaint.
Yeah, absolutely, Your Honor. I think it is in the complaint explicitly and implicitly. It's explicitly in there in, I believe, paragraphs 107 and 129, where we talk about failure to provide this kind of relief will give plan administrators the incentive to save their financial resources by denying such claims. I think those two are explicitly on it. We also allege variously that the failure to act for the exclusive purpose of providing the benefits is a violation of the duty of loyalty. And then I think just kind of generally the narrative story of the facts show that by its actions on its own, it did save itself the cost of all of this expensive treatment.
Do you agree in that context that the only entity that's at issue that saved money or was unjustly enriched is PSA because it's a self-funded plan? I mean, I get your other claim extends to the other two, but the unjust enrichment seems limited to PSA. Am I right thinking about that? Because they're the only ones that kept money that you allege they should have had to pay.
Well, Your Honor, I certainly agree with you that PSA is the direct financial beneficiary under the unjust enrichment claim. But I would say the other defendants are also, and obviously this was decided on the pleading stage, so we haven't developed a lot of the record yet, but the other defendants benefit financially, potentially from making cost savings for their client. You know, they've contracted with PSA. There's lots of third-party administrators, claims administrators out there. PSA could.
There are no allegations to that. I mean, I get you're speculating there might be some contingency story on loss, but we're fairly far afield from the complaint at this point, aren't we?
Your Honor, I appreciate that. We can't allege that, you know, for example, UMR gets financial benefits from denying a certain amount of claims or saving money because we don't have any of that information yet in discovery. So we've alleged the relationships that UMR's relationship with Quantum, UMR's relationship with PSA, and that they're hired, they don't do it for free, that this is all part of the relationship between the parties. But to know exactly what kind of incentives might be in contracts, what standards they might need to meet, what causes the renewal, things like that would be certainly.
So all right, so moving to the second piece on what I'll call the servicers, so the PSA and then the servicers, MC, UMR, etc. Help me understand what the allegations are that they're more than ministerial in role. This sort of goes to whether they actually have a fiduciary duty at all. I'm not saying that you can't imagine facts. What I'm asking is like, what have you alleged that gets you over that hurdle?
Yes, Your Honor. Well, first of all, I kind of answer that in two ways. One, UMR and Quantum are actual named fiduciaries in the plan. And so their role in being named fiduciaries would make them appropriate parties. But also in the Fourth Circuit, claims are allowed to be brought against the plan as such, but also any entities that have any control over the plan, and any entities that have discretionary decision-making authority over benefits determinations. And here, UMR is specifically named as the claims administrator. They're named as the claims appeal fiduciary. One of the denial letters that was on Quantum and PSA letterhead said UMR will make the final determination on benefits on this medical claim. Quantum, they used Quantum's guidelines. Quantum was on a determination letter by itself and on one with PSA. So the fact that these entities are pretty clearly exercising discretionary authority qualifies under mounds of Fourth Circuit precedent to be held responsible for under both these claims.
So, if I could, I want to follow up a little bit. You mentioned the Amara case and our Peters case, and I'm not sure how this really works given the text of A3, but nevertheless, the Supreme Court has a lot of cases that takes a pretty nuanced view of these equitable claims. And while Amara, says what it says, the Supreme Court, 4 years later, may have, kind of redirected parties, litigants, other courts to the Great Western and the Mertens case. And if you look at, Martinale and Great Western, they seem to be talking about, it's not a key factor is whether there's some discernible, discrete fund. And, whether that makes a lot of sense to me, that seems to be what they're talking about. Whereas if it's a claim against the general assets of a party, that in essence is a compensatory claim. Whereas on the other hand, if it's a claim against a discrete identifiable fund, it may not be. Do you agree with how I'm assessing that? And what does Amara do? I'm having a little trouble knowing what to do in light of all that, but it doesn't seem that your claim deals with the type of equitable lien type fund that is talked about in the other cases, unless I'm misunderstanding some.
Your Honor, your analysis is exactly right, which is impressive because it took me probably 15 years to figure out those cases. It's exactly right, but it doesn't affect this case. Mertens and Knudsen, I think, are both good law still. Martinale affirms that, but it doesn't apply, but it doesn't change anything in Amara. The distinction in those cases where they were all involving suits against non-fiduciaries. I think all of them came up as the fiduciary trustee suing a plan participant. And for example, the classic situation that comes up in these cases is when a medical plan has paid for services, and then the plaintiff let's say for a car accident, the plaintiff goes.
I think you're wrong about Mertens, but I may be wrong, but I thought Mertens was a fiduciary. I get Great West was that direction, right? Where is the fiduciary suing the beneficiary, but Mertens is the beneficiary suing the fiduciary, isn't it?
I don't believe so, Your Honor, and I believe Amara clarified that all Mertens does at its core is bars money damages against non-fiduciaries. And so
if that's right, counsel, your position is that if you're talking about a claim against a non-fiduciary, you have to have this kind of lien concept. But if you got a claim for breach of fiduciary duty, then you get equitable claims, whether they're monetary in nature or not.
Yes, yes, Your Honor, and that's exactly what Amara said. Amara said, look, we're not changing these other cases. We're kind of clarifying how they apply and how they work, but there's nothing in equity that prevents a plan participant for suing a fiduciary for compensatory damages. And so that's a big distinction between there. Moreover, Montanel didn't address surcharge. It was consistent with the Mertens holding of when settlement funds are completely dissipated, then that's it. A3 doesn't allow you to go after the general assets. Amara, and I think even Montanel even tacitly affirmed that Amara was working in sort of a different arena, so to speak, than those other cases. And I think in Peters, a year and a half ago, this court was right when it said that surcharge is appropriate equitable relief. Courts of equity utilized it to provide relief in the form of monetary compensation for a loss resulting from a trustee's breach of duty, or as you mentioned earlier, to prevent that trustee's unjust enrichment. That applicability applies when you're suing fiduciaries that are entrusted over the plan. I'll move on real quick to, I'm sorry.
Is your argument on that doesn't matter whether it's an unjust enrichment theory or whether it's the what you claim is your loss theory? Like
That's correct, Your Honor. Those are two different avenues to get the same surcharge relief under A3. Either one would provide the Holman estate with relief against the defendant fiduciaries whose actions directly led to him dying in Duke Hospital waiting on a heart.
Because I think to follow up on that clarification, if you look at Amara and look at Peters, they are both in the realm of, make whole remedies rather than, the recovering what the defendant retained claims. Am I right about that?
I think Peters was really focused a lot on the unjust enrichment.
Okay.
It spent substantial time on the unjust enrichment component, and that actually reminds me of another point that Peters made that was in direct contradiction to Judge Mullen's decision. One thing Judge Mullen held was that because Mr. Holman died, there was no financial injury, and Peters directly held that financial injury is unnecessary to have standing for surcharge certainly under unjust enrichment, but I would say also under a theory of a loss flowing from the breach of fiduciary duty. And I may want to clarify also earlier when Your Honor asked me about the loss, and it's loss of benefits, but it's also a loss of a right. There are a number of courts that show that if there has been an ERISA violation that results in harm, and I think Peters and McCravey are two of them, and Amara as well. If there is a ERISA violation to be shown that results in harm, that too could lead to the surcharge remedy of the trustee to compensate for the consequences of that. And we've alleged.
But the consequences of that are effectively like a tort compensatory damages, right? So like the value of the life, right? So, I mean, you might imagine if this was a car wreck case, right? And somebody negligently killed your client, we would try to figure out the value of a life, which is obviously a hard thing to do, but that's not the claim, right? Because that's traditional legal damages, right? You're not making that claim, or I don't see you to make that claim.
No, Your Honor, I think because it's ERISA and it's in a unique structure, conversation I have with all of my clients, no, you can't go seek pain and suffering, no, you can't go do this. That's exactly right. So you have to figure out a way to quantify it in some way, the loss of the benefits, the amount of the care, the associated benefits he may have had, the associated medical care. These are all things that we would have to use to try to show damages in some way to both prevent unjust enrichment and to cure the loss. I see that my time is up, and I will hold for rebuttal unless there are any other questions.
Thank you, counsel. Happy to hear from you.
Muscle relaxer and a script for 5 physical therapy sessions. Plan says, no, we'll give you 3, not 5. He goes to 3. He's improved. He's not better. He seeks the remaining 2. Eventually, that decision of the denial of benefits is overturned, and the plan says, you were right. You did deserve all 5. In the meantime, he's done his home exercises. He's actually all better. Doesn't need them. Didn't get the extra 2 sessions. Didn't spend any money on it. Doesn't need it now. Under current law, we don't monetize that. We don't say, well, it was $250 or $500 a session. Here's $500, here's $1,000. Under the Rose Rule, which is what would emanate from this case, we would be faced with claims to monetize that.
Can I ask you to set up what strikes me as the fundamental anomaly about this case is that, so I want to give you 3 situations, all of which I think your client has to pay, and how it seems anomalous that this is the one you don't. Okay, so let's assume for the sake of argument that after you denied him these benefits, a good Samaritan, whether it's a rich uncle or whether it was Duke Medical Center or someone had agreed to pay for this surgery, notwithstanding your failure to do so. And so the surgery actually happened. You would have to pay for that because it was ultimately concluded that it was covered, right? So this is the scenario where the surgery happens and someone else pays for it. You'd have to pay for that, right?
Assuming there is standing or a connection.
Assuming everything else about this case is the case. So if he'd paid for it out of pocket, his rich uncle or Duke Medical Center had paid for the surgery, you'd be on the hook. Okay, let's try another one. And oh, to be clear, in that situation, it doesn't matter if he dies a week later, right? Whether he's alive or dead, if a good Samaritan had paid for this surgery, you'd have to reimburse. Correct?
Yes, again, correct, assuming the standing connection, yes.
And now let's imagine that he's still alive today. If he's still alive today, you'd have to pay for the surgery, right?
If assuming that he has an obligation to pay back the Good Samaritan, otherwise it's a gift.
So, okay, it just seems weird to me that says in both scenarios, whether he's alive or dead, if the surgery had happened, you'd have to pay. And if he was still alive, you'd have to pay. But the one situation you don't have to pay is where we couldn't find a Good Samaritan and he died before you concluded that you were in fact required to pay all along. That seems strange to me.
Your Honor, I would put it this way. It's a situation that obviously gives rise to sympathy. This case is not the first one of this nature. There have been cases like this, even cited in our briefs going back 25 years. And the issue is, should this court take on itself the effort of revising ERISA to address this situation? This situation is a congressional, a legislative.
So I thought your argument would be different. So I thought what you're going to say to Judge Hyten's hypothetical is that he left out the crucial fact in hypothetical 2, right? When he said the defendant still, or sorry, the participant is still alive. The fact he left out is that is still alive and needs the surgery still. Because if he doesn't need the surgery still, so if it's denied, it turns out that the doctors were wrong and he doesn't need the surgery anymore and the doctors won't perform it because their surgery is dangerous, but they've decided that the risk is passed. In that scenario, if he's alive and doesn't need the surgery anymore, then you wouldn't be liable for it, right?
Correct. That's like my hypo of the PT sessions that are not needed. So in that case, there would be no need for it. If, however, it was determined that he still did need the surgery, then he would have the right to pursue that.
To provide.
Right.
But okay, so I get that. And so, but all of that suggests that the remedy is plaintiff focused. Right. And we see in lots of other cases, in particular, the Supreme Court's recent decision in Liu versus the SEC, that sometimes you can be simply defendant focused. And so it's not about what you took or what is owed or what belongs to the participant. It's about what you improperly got. Liu talks about disgorgement in a sort of stylized way, its version of disgorgement at least. And says that in that context, doesn't matter about the injury on the plaintiff side. We're only defendant focused. And so PSA, as I understand it, got to keep the money in its account that it would have otherwise had to pay out. And why is it that in Liu's phrase, disgorgement, maybe more correctly, some form of unjust enrichment or constructive trust. Help me understand for other equitable remedies why that's not like on all fours with what Lou is telling us equitable means.
Sure, for a couple of reasons. First, as has been noted in so many of the cases, ERISA is a balancing public policy situation where this situation of making benefits available.
I'm sorry, wait, say that again. So what you want me to do is balance public policy interests?
No, what I'm getting at, Your Honor, is that ERISA itself has been designed in a carefully balanced fashion. So encourage the provision of benefit plans, but that there are limitations.
Why don't you skip the public policy arguments and go to what equitable remedies means, right? Rather than, I mean, you can write your congressman about your public policy arguments, right? I got a statute, right? It says in A3, other equitable remedies. I got cases that tell me what that means. Like I'm not interested in the public policy arguments.
What the hypo that the court posed, Your Honor, suggests that is a repackaging of a benefits claim. So if
no,
we take
it's an unjust enrichment claim. It's not a benefits claim at all. It doesn't care one bit about the plaintiff. It cares only about you. What you are, this is disgorgement. This is Lou, right?
Have money that you shouldn't have.
You kept money that you shouldn't have.
It does, well, that under the way the equitable cases would work, as we see it, Your Honor, is those cases, all of them cited in the briefs, and the concept is that there has been some sort of a taking from the plaintiff to disgorge, or the unjust enrichment is wrapped around some sort of taking that comes from the plaintiff. In that hypo, all we really have is a repackaging of a benefits claim. If we look at Korotinska, for example, which remains good law, that in Korotinska, the allegation was that the benefit claim there was denied almost in a fraudulent way. It was intentional, it was designed. And so Judge Wilkinson in Korotinska for the court explained that whatever the circumstances are of a denial of benefits claim, that has to be rectified under A1B. It cannot become an A3 equitable claim. Otherwise, you're simply repackaging a benefits claim. And that's
what A3 says, right? To go back to what Judge Richardson was saying about the language. I mean, I agree with you that under lots of precedent, you can't succeed under A1B and A3. They are disjunctive. You can only, but when I read the text of A3, it presupposes that I don't have an A1 claim. I mean, the whole trigger for triggering A3 is you can only bring a claim under A3 if you don't have an A1 claim. But the argument that you're making now seems to say, if you're not making an A1 claim, you can't make an A3 claim. And I guess I'm saying textually, you can never have an A3 claim unless you don't have an A1 claim. So help me understand that.
In the cases, and I'll mention that from the plaintiff appellant's point of view, the Rose, they indicated that the Christine S case is perhaps the most thoughtful analysis or the best one to look to. That case does thoroughly go through this area of the law. And I believe what that case explains, and the other cases all line up with it, is that you can have an A3 claim in an A1B benefits situation if there's a distinct injury, if there's a completely different theory of law.
That is that you were unjustly enriched, right? But not that he missed out on anything. I sort of take your point as a pretty good one, that like, in essence, in Judge Hyten's hypothetical, right? He no longer, the hypothetical 2, whether he's alive or dead, he no longer needs the surgery, right? So we're fine there, right? So if I look at the plaintiff, I don't see a loss. When I look at you, I see an unjust gain. And that is a distinct claim from the plaintiff-focused version that you want to talk about the plaintiff. And that's a set of claims. I get that. But there's a whole separate set that don't look at the plaintiff, right? This is Lou itself, right? The whole fight there was the government didn't have any real interest in the story, right? But they say it doesn't matter. We're not looking at the plaintiff there. We're not looking at the party that's bringing the suit. We're looking at you and saying you got something that you don't deserve, and we're going to take it from you.
Understood, Your Honor. But what I would go back to is the way ERISA is structured. That claim is not cognizable, because it is simply another way to look at a denial of benefits. So that claim is foreclosed would be our position under the way the case law is presented. Every case that we have.
Can you just like help me just for a minute understand like how, I mean, maybe you say it's wholly unsupported, but how under the text I could possibly like reach that conclusion? Like I'm not even understanding how in theory I could read the text to get there.
A3 is for other claims that are not already addressed somewhere within the ERISA structure. Any denial of benefit. Do you
think that A1B addresses this claim?
I think that A1B addresses any situation.
So you think PSA can be sued and held liable under A1B? You're conceding that argument. You've argued against that, it seems like to me.
I am not conceding that A1B renders PSA or any of the other defendants liable. What I'm saying is A1B is for a denial of benefits claim. And that is what we are dealing with by different words. Whether you call it unjust enrichment as a result of the denial, all we are focused on is it is the denial of benefits that triggers it. A1B is the exclusive remedy for any denial of benefits. And the options that are in A1B are the ones available to a plaintiff.
How do you read that? But doesn't Amara and Peters, don't they essentially prevent that type of argument? I mean, those were benefits claims too. And they were
at this high level of generality that they ultimately arose out of.
They were benefits claims, but there was something more there. They turn on additional claims, additional conduct. For example, in Amara, the argument as alleged was that there was a misrepresentation as to the coverage within the plan. That is a separate claim that gives rise to the possibility of A3 equitable relief to correct the misrepresentation. And once the misrepresentation was corrected and the plan coverage as it was represented, it was supposed to be, was invoked, then the benefits being sought were available. So here, if we were to take the hypo from the court and the idea was that there was a misrepresentation of some sort about the benefits being made available to Mr. Holman, then A3 could come in to address that inequity. But if we're dealing with, as we are under these facts as alleged, nothing but a wrongful denial of a benefit, then we're limited to A1B. And we have seen that the particular circumstances here where there's
a misrepresentation here, right? Because the ERISA plan implicitly or explicitly represents that it's going to operate in good faith and award benefits where they're deserved and not award them where not deserved. And they didn't do that.
Well, the allegation is that
that would make any denial of benefits maybe that is, is that the case? Is any denial of benefits that turns out to be wrong a breach of a fiduciary duty?
No, but that would be the rule emanating from this case. I'm sure we would hear from the class action plaintiffs bar on any time we have a situation where a plan wrongfully denies negligently or intentionally, as was alleged in Korotinska, any benefit or part of a benefit. If you give, a cheaper medicine that's somewhat less effective but still cures you, but we monetize the difference, or you're released from the hospital after 2 days and you really felt you could have used another day and your plan should have authorized the third day. All of a sudden we have class claims monetizing all of that. Benefits claims are under A1B, and they do not, without a separate independent legal theory or additional tort-like action, go to A3.
That's your argument that if the remedy effectively is, or if the claim is really tied to a benefits decision, a coverage or not, denial or not, whether it results in unjust enrichment to a defendant or a loss, of a benefit to a plaintiff, that is under the first theory. It's got a rise or fall there. It's not available. And your position is that you have to have something such as in Amara, the misrepresentation about the change in plan, or in Peters, the kind of bundling up of the fees so that the deductibles get higher, aside from just a denial or not.
Correct, Your Honor. That is the position. Thank you.
So can I just want to make sure I understand the argument. So why would the theory of liability be what dictates the remedy? So A3 just says like other equitable remedies, right? And so it doesn't say, it doesn't seem on its face to turn on there being a separate theory of liability, is what I'm saying. So A1B is one remedy for a theory of liability, but A3 seems like the catch-all that doesn't require a separate theory of liability. It's a separate type of remedy, right? And so you can have one theory of liability that has two possible sets of remedies. All right, that's a common story, right? And so why does the theory of liability, what determines the distinction between A1B and A3?
I agree with the court. That is a common way to look at it. But Davila, for example, from the Supreme Court, focuses on the idea that A3 is a safety net, not a catch-all, not a, is there any other way that I could be relieved here? Or is there any other benefit I could obtain or any other claim I might be able to bring? Let me top up into A3. A3 is a safety net if there is nowhere else under ERISA to go. And it is clear under Davila and the other cases that A1B is the source. So there has to be that separate claim. And that's what Christine S. and all of the other cases that have analyzed the interplay between A1B and A3 have come out to say.
I mean, that may be right, but that seems like it's fairly atextual. I mean, the looking at the text, it doesn't read that way. Maybe the case law gets you there, but the text doesn't say it's a catch-all, doesn't read like it's a catch-all. It seems like, anyway, maybe the cases do it, but it doesn't look like Congress did it.
Thank you. Unless there are any other questions, I see I'm well past my time, but thank you very much.
Thank you, counsel. Mr. Boone, I think we'll hear from you.
Thank you, Your Honor, and may it please the court. Brian Boone from Alston and Byrd for UMR. I appreciate the court's allowing me to appear by Zoom today, given the circumstances, and I apologize for my voice, and I'll be brief. I want to highlight one argument that applies uniquely to the non-PSA defendants, and that group is UMR, Quantum, and MCMC. And the argument is this: Rose acknowledged in her complaint that only PSA was responsible for paying benefits under the PSA plan. You can see that at JA pages 13 and 14. And Rose, I'll read the allegations. She alleges that PSA is the plan administrator as well as the plan sponsor, that the plan is fully self-funded, and that PSA assumes the sole responsibility for funding plan benefits. So Rose has acknowledged in the complaint that the non-PSA defendants were not responsible for paying for the heart transplant. And that undermines the claims against the non-PSA defendants. They would have never been responsible for paying for the heart transplant because they were not responsible for paying benefits under the plan. In her appellate briefing, Rose says that she seeks the value of the heart transplant on the theory that it's the amount that the defendants avoided paying by the alleged conduct. And she says that theory sounds in unjust enrichment, but that theory doesn't work against the non-PSA defendants because they didn't avoid any expense.
But counsel, just to talk about that issue more, and and maybe that's right. I mean, I certainly understand the position that your client wasn't enriched in the same way as the allegation goes because it wasn't supposed to pay the plan. But at least in the unjust enrichment, we got two words: one's unjust and one's enrichment. Maybe PSA didn't do anything unjust. And so, how does that work? Would that insulate you because you're not enriched and insulate PSA because it didn't decide?
I'm not suggesting that there should be any liability against PSA. I'm just saying that for the non-PSA defendants, they didn't avoid any expenses. They weren't responsible for paying for any claim under the PSA plan. So it's they were never unjustly enriched in any sense. So that claim would fail.
So I understand. Assume for a minute I agree with that. The problem is unjust enrichment is not the only theory that has been brought, right? There's also sort of a plaintiff focused side, right? That they claim there was a loss that is compensable under A3. Help me understand why that doesn't work. Sort of assume away the unjust enrichment piece. Help me understand why, and assume that you're a fiduciary, just for purposes of this answer. Why doesn't the loss that's alleged here suffice for an A3 claim?
Are you asking about an A3 claim against the non-PSA defendants, I take it?
Yes, I'm putting PSA aside because I take you're not representing them. You're representing the servicers. And so what I'm trying to get at is if I take unjust enrichment away and I really focus only on a claim of loss under A3 and not unjust enrichment, why is that not equitable relief?
Sure, I think I had two responses. The first is I'm not quite sure what the loss alleged is here. I know that in his briefing, Mr. Adams suggests that the loss might be just Kyrie's death, Mr. Holman's death, and also variously suggests that it could be the loss of a right under ERISA. So it's not clear to me exactly what the loss would be here, but in any case, awarding the estate.
I take him to agree that it's not the death and the loss of life. I take him to be instead it's the loss of the benefit.
Sure. I guess my other response would be that 502A3 focuses on remedies, right? And so it's focused on appropriate equitable relief. And the Supreme Court cases make clear that compensatory damages that run against general assets never, ever, ever qualify as equitable relief.
So I take his argument to be that's right, and that's why we haven't sued for his life like this was a car wreck, because that'd be compensatory. But instead, what I'm suing for is the loss of the service that I was entitled to.
Which sounds to me just like a repackaged version of the benefits claim that Mr. Adams had alleged in the complaint. In any case, Mr. Holman would not have been.
Your move is to go with PSA and say, if it has any relation to benefits, like it's got to be A1B or bust.
I think that's what Cortesca says, Your Honor. Yes.
Anybody, I didn't mean to take up all your time. Anybody got other questions for him?
The one other thing that I would say, if you would indulge me, about Peters. In Peters, I think this court said that there was something more. It was not just a straight up benefits denial. There were allegations of self-dealing, I think, in that case by Aetna. So there was something more. It wasn't just cut and dried benefits denial. And unless the court has any other questions, I'll yield. Thank you.
Thank you, Mr. Boone. We appreciate you being with us and are glad to have you. Mr. Adams, I think we've got a few more minutes from you.
Thank you, Your Honor. To that point, I guess that the court discussed with both of my able counsel opponents, that it has to be connected. If it's in any way connected to an A1B claim, it has to be an A1B claim. That just practically doesn't make sense. First of all, Verity, Amara, Peters, all of those cases involved both. And in fact, they weren't able to determine a remedy until much further after a motion to dismiss and summary judgment.
Their point is that those cases have a plus factor, right? They've got another issue. And so help me understand why that, I mean, it is a distinction, right? So it is true that those cases involve some other claim. Help me understand why you think that distinction is one that doesn't matter.
No, Your Honor, I think that's a great point. And there is something more to this case. If the facts of this case were that they denied Mr. Holman's claim and a court later overturned it and called it a wrongful denial, I would agree there's not an A3 claim. But the facts of this case are they applied an exclusion that wasn't in the plan. They applied guidelines that they weren't allowed to apply. MCMC found alcohol before cardiac transplant is not listed as a benefit exclusion. These are misrepresentations of what the plan requires. And it is because of those misrepresentations and because of those applying incorrect plan provisions, incorrect exclusions, incorrect guidelines that caused the loss, that caused the death. And so if you connect every A1B, if there's any,
like their argument there is, yes, any wrongful denial by definition is wrongful, right? And so it's wrongful. It means they've misapplied something. And so that's not something more than a straight benefits denial.
Well, Your Honor, I would disagree with their characterization, because a representation that a plan requires 6 months of alcohol free in order to approve a benefit when there's no such exclusion in the plan.
But that's not a, but counsel, I mean, normally when you have a representation that induces some sort of action. That was a reason, and it may have been a wrong reason. Sounds like it was a wrong reason, but calling it a misrepresentation when it's a reason didn't induce any, reliance. So, and I think that's, that is, just assume we disagree with you that there is and that we think there is a distinction. Tell us why that shouldn't matter.
I think, Your Honor, under Amara and Verity, they are saying, and the Jones case out of the 8th Circuit, if there's an allegation of misconduct in the claims processing, which is what happened here, that's sufficient to withstand an A3 claim separate and from an A1B claim. On its own. And it makes sense, because if there weren't that, then you could never, a plan could apply the back of a Lucky Charms box to a claim. And if that person dies, then there's no relief. And that's just not a result that could ever be tenable. It's certainly not what Congress intended in affording access to remedies, to sanctions, to access to the courts. You could no matter how egregious the actions were, and they were egregious. I mean, there were 3 appeals that were denied on false grounds.
Mr. Adams, can you just explain for me a minute? I mean, one of the challenges that I've got is that this theory that there's got to be a separate claim from a benefits denial doesn't seem to match up well with the text of the statute, right? Because A1B and A3 are distinct methods, right? They're not mutually exclusive in some sense that you require an additional claim in order to get into the A3 box. Why isn't that the reason that those claims had an additional claim doesn't make any difference? Because that's the theory of liability, which is a different question than the remedy.
If I'm understanding the question correctly, I think that it doesn't have to be connected. What Amara says is that there is fiduciary misconduct that leads to a loss. If there's just fiduciary misconduct, that's remediable with a claim for compensatory damages. Anything that a trustee, because a trustee has to be held to account to, and the unjust enrichment is a way of doing that also. But I think the A3 claim is separate and apart, particularly with Verity's warning that where there's no adequate relief elsewhere. So even separately from that, if there is no A1B claim, which is what the defendants argue, the A3 claim stands alone because there's no other adequate relief available in the statute.
Counsel, I have another question. Whether it's unjust enrichment or surcharge or disgorgement, assume we're in those sort of equitable claims that I think, as Judge Richardson said, are defendant focused rather than plaintiff focused. Do you have to show that the and my question relates to PSA. Does the PSA defendants, do you have to show that they did something wrong, that they were, they did an action that was that caused those defendants to be able to retain money improperly?
No, Your Honor, it's because of the way they set up their plan. They structured it for UMR to be the claims administrator for medical claims, for Quantum to also be named fiduciary. when you set up and delegate your fiduciary authority to others, then ultimately you're all responsible.
It sounds like your answer is maybe that might be an issue if they hadn't set the plan up and done it this way, if they were somehow insulated or, distinct from whatever decision, resulted in them retaining the money. But if it results from their, the plan they set up, it's kind of imputed to them. Is that the thought?
Yeah, I can't think of, Your Honor, I can't think of a situation where the actual plan administrator and funder and actual plan, because this happens a lot with medical. They look for medical people with expertise, and there's a number of different companies like that out there, which I think goes to the point we talked about earlier of they did have something to gain from it. But when you set it up, you're not absolved of liability. And that's very standard in the Fourth Circuit, where both the plan administrator, the plan, and the people that made the discretionary decisions. We don't know exactly who made all of them. PSA was on the letterhead of at least the final.
I appreciate that issue may not be something we know at the pleadings. I'm just talking generally if the case were to proceed, how that would need to be played out. But I appreciate your answer.
Over. If there are no any other questions, then I will thank the court for the hearing today, and I appreciate it.
Well, we certainly appreciate counsel's help on this case. We would normally come down and greet the one of you that's with us, but instead we'll greet you all from afar and hope that we have a chance to see you again where we can do it in person. And we'll proceed on to the third case. Number 21-4654, United States versus Covington.
Thank you, Your Honors. May it please the court. I want to focus on two aspects of this record that demonstrate the district court prejudged Mr. Covington. First, the district court's statement at sentencing that it was imposing the statutory maximum before defense counsel even argued. And second, the court's contemporaneous statements that it was making a record for this court and allowing defense counsel to make a record for this court. To make a record to document a decision that's already been made. But first, at sentencing, the district court, and without hearing from defense counsel, the district court specifically said, quote, "I am going to upwardly depart and vary to the statutory maximum of 60 months, end quote." That is unequivocal language. But the district court did not leave it at that. The district court accompanied the imposition of sentence with a statement, quote, "I am making a record here for the Court of Appeals to review," end quote. And when defense counsel asked to be heard, the district court didn't say, "Oops, my mistake, let's start over." Rather, the district court said, quote, "Yeah, go ahead and make your record because you're going to appeal it and they're going to say whether or not I was prudent and careful in going up," end quote. Was prudent and careful in going up, past tense. Those statements confirmed that the district court had already made up its mind, and it didn't matter to the district court what record defense counsel made. That record was for the benefit of this court, not for the benefit of the district court. You know, the government citation.
Don't we have district courts all the time that make decisions? I mean, this happens in the motion and eliminate context. And we often have district courts that are making decisions or notifying the parties of what the decision is. And even so, we all recognize that district judges reconsider. That's why we have all these motions to reconsider. It's why you make contemporaneous trial objections, even if it's been addressed by motion and eliminate, because we recognize that, yes, people make decisions, but the nature of being a judge is that you recognize when new information is added that I might change my mind. And that's like a simple part of being a judge, is that we are continually making decisions, but we are also continually aware that if you add new information to the mix, that might change the calculus.
I understand that, but I think we can't get away from the unequivocal language of the imposition of sentence accompanied by the statements that you can make a record for the Court of Appeals.
Actually impose a sentence before, right? He said that's what he was going to do. I get that. He's signaling. I mean, you've done this enough. We often, you know, as lawyers appeared before district judges, and it's often quite helpful when the judge comes out and says, here's where I am. But I'm happy to hear from I mean, this is a common, you know, story in district court world where the court comes out and says, here's where I am, but I'm happy to hear from everybody and I'll take full consideration of what you say. But rather than start at the beginning, let me tell you where I am so that, you know, we've got a good starting point.
You're right, Your Honor. But this case is distinguishable in terms of, say, even at one end of the spectrum, the Gutierrez case cited by the government. In that case, you know, the government, the district realizes he hasn't heard, says, okay, let's start over. Let's scrap that. I'm going to vacate the sentence. I want to hear from the defense. But you could even do something less than that.
The sentence, right? Like that isn't like a preview of what the sentence is going to be. That's the actual sentence.
Yeah, well, we view Joint Appendix page 28 as the actual imposition of the sentence, given the accompanying statements.
So you think like all the conditions of supervised release that they weren't announced with the sentence?
They did come eventually once, you know, defense
right, because that's when the sentence was announced, right? Not on the page 71.
But I do think this case is distinguishable from a case like Engel because of those comments about the record and the past tense the district court is using in terms of having already made up its mind. Another option the district court could have exercised was to say, you know, I'm inclined to give 60 months, but I'm open to arguments that it should be lower. That's you know, there were a few different options the district court.
He said he was open to arguments, didn't he?
He did say, but what ended up happening was, although he said he would consider the defense arguments, he didn't actually consider the heart of the defense arguments when they got to make the record. So it's particularly apparent the district court didn't consider the arguments because the district court didn't even order Mr. Covington not to drink alcohol on supervised release. That the guidelines recommend that condition, probation recommended that condition, but the district court did not ever say anything about that condition, not in the transcript, not in the judgment. Alcoholics should not drink alcohol and certainly should not be allowed by a district court judge to drink alcohol for 3 years on supervised release. You know, this case is also, we can benefit from a government citation to Pitzinger in the 28J letter, actually, of the Fifth Circuit, because in Pitzinger, the court recognized that an opportunity to allocute is, quote, not meaningful if the court has already stated in conclusive terms that a particular sentence will be imposed. So, Your Honor, even if you don't believe that that was the actual imposition of the sentence?
The defendant allocated here first, right? I mean, we'd heard all about alcohol. I mean, that was an issue that had been addressed first.
I'm even giving them, you know, they want to analogize to allocution cases and okay, to a certain extent, that's fine. But if we want to look to those cases, let's look to what it actually said. And so it's not meaningful if the district court has already stated in conclusive terms that a particular sentence will be imposed. So even if you want to view the Joint Appendix page 28 as not the actual imposition of the sentence, it was stated in conclusive terms.
And I'm looking at the language of Rule 32. So I realize the alleged violation here is not allowing defense counsel to speak. But Rule 32 talks about letting the defendant speak. It talks about letting defense counsel speaks. It talks about letting the attorney for the government speak. And it talks about letting any victim speak, right? Those are all in Rule 32. And if we say this was okay, then presumably it would have been okay if he did any of these things before letting the defendant speak, before letting government counsel speak, and before letting any victims speak too, right? Because I don't see there's any textual basis to say the rule is different for letting defense counsel speak. The rule has to be the same for all four of those.
That's correct. Yeah, I agree. This becomes a fundamentally different case and much more mitigating when you hear both sides of this story. This really could come out differently on remand because, a district court who listens to both sides might reasonably conclude that society would be better protected, right, if Mr. Covington received less than the statutory maximum, but more time in intensive residential alcohol rehabilitation as soon as possible. Because a judge who listens to both sides could determine that Mr. Covington's alcoholism really does fuel his criminality. And if we can do something about his alcoholism, maybe we can do something about his criminal behavior.
Do you think there's any realistic possibility this case would come out differently before this district judge?
Well, the remedy is to vacate and remand for resentencing. I also recognize that remand to a different district court judge is an extraordinary remedy. We didn't ask for that in this particular case. We think that this particular district court could be fair if he listens to all sides of the story before making a decision. And so, but we would leave that up to this court in terms of that particular aspect of the
whether the first statement, which I tend not to think is enough for you, where the district court literally at the time of the plea colloquy seems ready to impose a sentence. I mean, it's hard for me to read this record that this district court had not decided from the instant this case got in front of him what was going to happen, which turns out to be precisely the thing that happened.
I absolutely agree. But again, without the benefit, having jumped to the end, to the conclusion, you can't ever really meaningfully go back. But there will be time, right? Having intervened in here before this goes back. And I do think that this judge could make a fair decision. So we haven't asked for that particular part of the remedy. Alcoholism is a disease. So realistically, I do think Mr. Covington could receive a lesser sentence if he appears before a district court that does not prejudge that sentence before hearing both sides of the story.
Can I ask you about the enhancement issue for a second? I mean, do you contest that your client at the time of sentencing had a pending state law charge for common law robbery?
No, he did.
So why isn't that just ballgame in terms of whether or not the enhancement applies? I mean, there was this whole distracting thing about whether the federal carjacking statute is satisfied, but it seems pretty obvious that there was an underlying state law felony.
Right. So, but the problem is the district court found a crime the government did not prove. That's the heart of our issue on appeal. And since the government bore the burden to prove the crime, they shouldn't get a second bite of the apple under Parker. But if this court disagrees with that, it should at least go back for the district court to make a finding in the first instance of a particular crime. Give the defense a chance, because again, there's a lot of evidence on this record. He suffered a head injury in the accident he caused, and then he said he couldn't even remember. Pardon, what happened. So that calls into question whether he could even form specific intent to commit any specific intent crime.
As I recall, robbery. The probation officer mentioned the state law crime, right? It wasn't like the state law crime is coming out of nowhere.
Sure, it was in the PSR. That's correct. But the focus
on the enhancement issue, reading the transcript, it looks like that's almost conceded. Maybe I'm wrong with that. Is that do we review that?
It really wasn't fleshed out. There wasn't much of an argument there.
Is it preserved? Do we look at it at plain error?
Well, we've got a finding, I think, of the district court that carjacking was established, and that's what we're attacking on appeal. But really, I rest on the briefing as to that particular issue, as to issue 3. If there are no other questions, I'll see you on rebuttal if that's okay.
Thank you, counsel.
Thank you.
Happy to hear from you. Welcome to take your mask off. You're not required to, of course.
Sometimes I forget to take it off. Good morning. May it please the court. I'm David Bragdon, and I represent the United States. I'm happy to start wherever the court wants, but I did want to, with the court's permission, shed a little bit of light on the arraignment statements by the district court judge, because I'm not sure that came out quite fully in the briefing. And in particular, this case was fairly unusual in its procedural posture and just how fast it went. And so from the arrest to the arraignment is less than a month and a half. And, you know, there was a criminal information done, which is actually—
Sorry, from the arrest to the arraignment?
Sorry, in the Eastern District of North Carolina, we call plea hearings arraignments, and that's very confusing.
Right.
So
I'm like, that's a different problem if it took them a month to arraign him. I'm sorry, I didn't realize we had that problem too, but.
I think are the only district in the country that does that. And I usually call them plea hearings in my brief, but sometimes I forget.
Okay, all right.
So from the arrest to the plea hearing was less than a month and a half. And it was also done by criminal information without a plea agreement, which I've never seen that being done before. And then even more importantly, it's exceedingly rare to actually have a motion to expedite it and do it all at once. And when the defense made this motion, the specific reason they gave in paragraph 4 of their motion is because defendant believes it possible that he could serve a sentence longer than that which is likely to be imposed under the guidelines if he is arraigned and sentenced in accordance with standard court procedures. And local rule of the district court does allow you to make a motion to expedite in that instance. The idea is if you're likely to serve more prison time before you get to arraignment, then you would then a judge is actually likely to give you under the guidelines, then obviously we want those to go faster. And so this motion was made by the defendant with that representation, and that's the backdrop of the court's comments. So the court is now at the hearing, the motion hasn't been withdrawn, it hasn't been ruled on, and it's saying this is a 5-year sentence, you know what, and I recognize I'm reading some into it, but I think what I read into the court's comments is, do you really think it's likely that he would serve his whole sentence before we get to the sentencing? And so that's the background of those comments. And I think it does put—
Say that one more time.
I think the court did not believe it was likely that it needed to expedite the sentence because it didn't think it was likely that he was going to serve his whole sentence before they ever got to sentencing in the normal course.
But didn't he then grant the motion to expedite? I mean, in a sense, right? I mean, it is, I take your point, but if he was really addressing that issue, then why? Because it was expedited, right?
Well, the specific request that they made was to have sentencing at the time of arraignment. Sorry, at the time of the plea.
I understand the language now. It took me a minute, but I'm with it.
That was the specific request, and the court didn't do that, you know, and so it did, you know, granted in the sense of let's do this fast, but it didn't, it's not, let's not do this all at once, you know, and so I think that's the background of those comments.
So can I move forward to the plea hearing and ask you a question that builds off my question to your friend on the other side that points out these are all in Rule 32? So I want you to imagine that everything in this case played out exactly the same way, except for 2 things. First, the district court said what it said before it invited the government to speak. And 2, what the district court said instead was, I'm going to vary way downward and give him time served. And then the government counsel gets up and says, maybe you should let us talk. And the district court said, go ahead, make your record. How do you suppose the government would react if that had happened?
Well, Your Honor, I'm in a good position to answer that because I actually had a similar situation happen to me in district court, in front of this court, actually, several years ago. And we had prepared for sentencing. It was a postal fraud case. The amount of loss was not exceedingly high. It was $100,000. And The court heard from the defendant. It then had a colloquy with defendant and defense counsel. It looked down at the record and then looked up and said the judgment of the court shall be probation. Goes through, specifically pronounces the judgment, supervised release conditions, and so on. We, the government, then objected because we hadn't had the opportunity to be heard. And I think because we made that specific objection, we didn't just ask for the opportunity.
But you objected. You didn't just say, oh, it's cool. We'll assume that that was maybe a tentative thing. You thought that the district court had just violated Rule 32.
And to be fair, it was a specific pronouncement. It wasn't this kind of case where the court had said, this is what I'm going to do. The court actually said, this will be the judgment of the court, read out supervised release conditions and everything else. And when the court did that and we objected, the court suspended judgment and gave the government the opportunity to be heard. We were heard. We presented our arguments. The court reimposed the same sentence and we didn't appeal. Because the court, we flagged the issue for the court. It resolved the concern that it had. And the problem was fixed. I think this mistake does happen sometimes. And here, I don't even know that.
Wait, so that strikes me as a really important thing you just said. Do you concede this was a mistake?
No, I don't. I think it's a mistake if the court actually pronounces judgment. I think in this case, the court did not pronounce judgment. And so I was trying to think about this and I was thinking, it is not the rule that a judge can't have an opinion about what the sentence is going to be before they come in. For us to have that rule, judges would have to come in unprepared. That would be the only way for that to happen, right? And it's also not the rule that judges aren't allowed to give their opinion to the parties, because it's often helpful to know where the judge stands. If the judge thinks this is a probation case, we, the government, want to know that. It gives us a chance to specifically address the court where it is and not in some hypothetical state. And here, but
you have to acknowledge, yes, I agree with everything you just said is totally fair. It strikes me as totally right. But at the same time, and I'm not saying Fifth Amendment, 14th Amendment, I'm saying due process with a little d and a little p, notions of due process. Rely on the notion that before we send someone to jail, we give them and their lawyer an opportunity to speak, and that we don't convey that nothing that they say could possibly make a difference. Even if the court, in fact, in its heart is convinced, right? You have to acknowledge that there are sort of serious due process problems with telling a defendant, here's what it's going to be. Oh, wait, I guess I'll listen to what you say, but really I've already made up my mind because I've already just told you that I've made up my mind and nothing you say is going to persuade me. There are due process problems of a little d, little p, maybe a capital D, capital P with doing that, right?
Yes, Your Honor. And I think that this would be a harder case if the court had ended with make your record. But that's not the last thing it said. In this case, and I want to make sure I get this right, it says, following that, I will take into account and deliberate on every one of your arguments. And then following the arguments, the court says, I've listened deliberately to each and every word you've said on your behalf. This is not a script. It's not part of some pre-read. The court is individually telling him, I've listened and I find I'm going to listen. I have an opinion, but I'm going to listen to what you have to say. And I did listen to what you have to say. And so to me, that—
Wait, what did the court say ahead of time? I agree that it said after the fact, I have listened. Where did it say I'm going to listen?
So on JA 29, and I'll read the whole exchange so it's clear, and I will take into account and deliberate on every one of your arguments, but there's no way that a guideline of 37 months is adequate punishment given his recidivism and given the fact that he was on escape.
So I'll listen, but it's not going to change my mind about anything. That sounds like what that says to me. I'll listen in the sense that I'll hear you, but by the way, nothing you say is going to change my mind.
Well, first of all, let me take a
Is
little
there
bit
anything
of—
wrong with that? I mean, I guess maybe I'm rubbed, right? So if he comes out and says, listen, this is the most serious offense conduct I've ever seen, right? I've read the PSR. I've read everything about you. I've heard, I think at this point, he's heard from the defendant. And so he's heard a fair bit of information. Maybe it's not all the information, but he's heard a lot of information. And he's thinking, seems fairly here, that this offense conduct like ought to be carjacking, right? Not escape. And so I think the appropriate sentence, if I had the authority to do it, would be 22 years. And so I can imagine lots of mitigating circumstances, but I can't imagine those that would take me from the 22 years, hypothetically, that I think is the appropriate sentence for this offense conduct for someone who's this type of recidivist who did these sorts of things. And so I can envision lots of things that might mitigate, but I can't envision something that would take me down below 60 months. And I'm capped at 60 months. So that's all I can do. I mean, it seems like to me, what's really driving here and what seems to be missing is that this is a sentence that's driven by his belief this offense conduct deserves more than 5 years, a lot more than 5 years. And that seems like a not unreasonable position for him to take. And so I guess I don't have I'm having a little bit of a hard time understanding why that's even a problem. You seem to think, oh, that's sort of a problem. Seems like to me, that seems like an eminently reasonable position to take, particularly because he says, listen, that's my view, but I will listen to what you're going to tell me. I'm going to listen, right? But I want everybody to know up front, like, I think this deserves a much longer sentence than what is available in this case, right? And that I, as a district judge, feel unfairly constrained by the mandatory minimum, right? I mean, we have district court judges do this the other way all the time, right? Where they say right out of the gate, this is a 10-year mandatory minimum. Like, I would impose much less if I was not constrained by this statutory maximum. I think this is a 2-year sentence, but, the government has forced me to impose a 10-year sentence. And they often do that without hearing from the government. And we don't find any problem. Here is the statutory maximum, just like it would be with the statutory minimum, not that he's sort of made some decision with broad discretion. He lacks the discretion that he wants.
I agree.
I know there's no question in that, but don't you agree? One of my colleagues likes to say, don't you agree?
I do agree with that. I do agree with that. And I think this only step that remains is the court does have to listen. And the court did listen. And so I think, to me, yes, a court can come in with an opinion. Yes, he can come in with a very strong opinion that's not likely to be swayed, but he has to listen. And here the court says he was going to listen, did listen, and said he listened.
Can I ask you about a part of it? I think that's all fair. Can I ask you about a part of it that I find troubling in the transcript? I confess I don't know exactly what to do with this. What possible rationale is there for the district court's summary refusal to require alcohol treatment? I mean, candidly, that just seemed gratuitously nasty for no apparent reason that I could see.
Your Honor, I wondered about that too. And one of the things I did is I went and looked at the original transcript of the sentencing from 2010 or 2011. This is my theory. Some of it, what I can tell you from the record is in that original transcript, there's similar discussion about the defendant's struggle with alcohol, of his dad being an alcoholic, his mom on substance abuse. The court there imposes recommends substance abuse treatment without even being asked. And so that's something the court does. The court engages in a fairly detailed colloquy with the defendant, asking him questions about his work, his employment, his life, and so on. I think trying to get a measure of who he is. And my assessment is the court really believed this guy was going to get treatment. It was going to make a difference. He was going to do this, and he didn't. He's in prison for a lengthy period of time. He doesn't do the treatment. He smuggles alcohol into prison. He then, goes out, commits all these crimes before he's even finished his federal sentence. And at the beginning of this sentencing, when the question is, when the defendant's talking about his alcoholism, he says, well, I didn't get treatment the first time. And he said, well, who's to blame for that? And so the court clearly thinks that the defendant is at fault for not taking advantage of these opportunities the first time. And he then decides not to recommend those opportunities. Now, BOP can still make them available, but he decides he's not going to make those recommendations. And my inference from all that is that he no longer believed the defendant was a good risk or a good beneficiary of these limited resources based on his past conduct. I can speak about the other issues, but if the court doesn't have any other questions, then I'll ask to affirm.
Thank you, counsel. You've got some time. We're happy to hear from you.
Counsel, could I ask you to address the forfeiture issue? Because that had troubled me a little bit, and prompted by your colleague on the other side saying it. Why isn't this forfeited? Why wasn't it defense counsel's obligation to stand up and say, Your Honor, I believe to the extent the court has just imposed sentence that you violated Rule 32, and to alert the court to the error? I don't see anything in the transcript that suggests defense counsel did that.
For two reasons, Your Honor. First, after the district court imposed the sentence on Joint Appendix page 28 without hearing defense argument, defense counsel asked to be heard. That in and of itself, right, alerted the district court to the constitutional and procedural problems with imposing a sentence without hearing from defense counsel. As Your Honor pointed out,
I'm not sure that right.
Due process.
Do you mind?
Oh, I'm sorry, I forgot.
No, I know. It's just a little hard to hear you. If you hadn't taken it off before, I would have asked you to done it. But
due process.
Why is that? I mean, because you could imagine the says, listen, Your Honor, you have violated the rules and arguably my client's constitutional rights by effectively imposing the sentence without having heard from me, right? That's obviously like I don't say the gold standard, but that'd be a great objection. But why is it, Judge, I want to be heard, suffices.
Suffices to say that you've already done something wrong, right? Not that I'd like to be heard going forward, but that you've already done something that was a problem.
Welcome to my world of wishing but here's the thing, right? Two things. One is due process is grounded in two things. These words are pounded in my head from my Civ Pro teacher, Adrian Fox, 20 years ago. Notice and an opportunity to be heard, right? So opportunity to be heard, due process, that's what you think. And the district court also responded by acknowledging there was going to be an appeal, right? You're going to appeal this. So I think for those reasons that would preserve it, but also what
he says there, I mean, he's going to appeal it on lots of things, right? Like, not that he's going to appeal it on this issue, right? He's going to appeal the 60 months, right? I mean, because we have lots of case law about appealing sentences. I mean, most people now appeal them, right?
And he said they're going to say whether I was prudent and reasonable in going up. That's
prudent and reasonable in going up, not prudent and reasonable in imposing sentence before you object, before you could speak.
And there is another ground that preserves this claim, and that's under this court's precedent in Lynn. A request for a lower sentence preserves procedural sentencing error on appeal. And this court, the particular error in Lynn was a failure of explanation of the sentence, but the court in Lynn did not limit its holding to that particular kind of procedural error in Lynn or in any of the cases following Lynn. And if you think about this, imposing a sentence without even listening to a defendant's arguments constitutes a failure to consider and address those arguments, which is quintessential error under Lynn, Blue.
Can you help me understand what the defense counsel argues that was not in the PSR and the defendant's colloquy? Like help me understand what does the defense lawyer add? I mean, at some level, the defense lawyer, I think you would agree, the defense lawyer is additive in many respects to the PSR information and the defendant's colloquy. And what I'm trying to get at is what do you think is important about the addition?
Here's the distinction, because a judge could reasonably find that being drunk during a crime is absolutely not mitigating. But being a lifelong severe alcoholic that you inherited from your parents, that is mitigating, right?
But
and that's the difference
between. But then the PSA, goodness gracious, the PSR includes discussion about his alcoholism. I mean, it doesn't just say he had been drinking, right? I mean, it raises, as does the defendant in his colloquy, alcoholism as a group. So what I'm trying to get at is, what do you think the defense lawyer added to what had come before? Now, this is a practical question. It's not really relevant to the Rule 32 strict analysis, but when we think about whether this error mattered in any way, what did the defense lawyer add that wasn't known to the district judge before the defense lawyer spoke?
Yes, Your Honor, I'm out of time.
Please.
Is it okay?
Please.
Okay, thank you. 2 points. One, a pre-sentence report is no substitute for the arguments of an advocate.
Okay, I understand that. What I'm trying to get at is what was added.
Right, sure. What was added was the history and characteristics of Mr. Covington. Not that he was drunk during the crime, but that both of his parents had addiction issues.
Okay, let me just ask it more specifically.
Yeah,
one more time, and then you can choose not to answer. It's totally fine. But what specifically was added that wasn't in the PSR? Like what facts or argument or inference was added, right? Because history and characteristics of the defendant were discussed in both. I'm looking for like what was actually added by the defense lawyer that wasn't already known.
Right. Well, but it's the advocate's argument that is meant to persuade the district court, right? So he says he's drinking profusely by age 16. We have to put this in context, right? His parents failed to even send him to school except for 1 year. His entire criminal history was directly related to his alcoholism. That was an argument that's not right. It's not in the PSR. That's the government. That's the defense argument. Look, there's a root cause here that we could solve by getting him treatment. Was there evidence of that all of his crimes related to alcohol, or was that just the defense lawyers? There is. I mean, where is that evidence? When you look back, the PSR, right? Right, but you have to put this together from an advocate's standpoint. And again, another argument in there is from the advocate saying a sentence of 30 to 37 months will give enough time for the substance abuse treatment that he needs, right? That's another argument that it has to be an advocate that makes that argument to make it mean anything to the decision maker. I appreciate your time. Thank you.
Thank you, counsel. As you both well know, we would love to come down and greet you and thank you for your argument. We hope in a time soon, we'll return to that tradition and that we'll get a chance to see both of you again. Thank you for your help. We'll proceed to the final case of the day, number 20-1910, Allen versus Atlas Box.
Yes.
To hear from you.
Morning, Your Honors. May it please the court. Jonathan Ellis on behalf of appellant Andrew Allen. The principal question in this appeal is when is a Title VII action commenced, where a plaintiff delivers his complaint to the district court alongside a motion for IFP. Is it commenced when the complaint is delivered, or only after the IFP motion is resolved and any filing fee is paid?
Can you, sorry, just because you start with this idea of the IFP motion, does that matter? Like what would your view on the case be different if he didn't include the IFP motion? Does that make any, I mean, you just mentioned it right out the gate. And so we tend to mention those things that we think matter. And so I'm curious, I sort of took your argument to really be at its core, IFP or not, filing fee or not, doesn't make a difference.
Absolutely, Your Honor, that's correct. I think the IFP motion is what tripped up the court below. And so I mentioned it here. I think that's what my opponents think is a differentiating factor. I don't think it has any bearing at all. I think the correct answer is the one that the majority of circuits to have addressed this question and similar ones have reached, that the case is commenced when the complaint is delivered.
And does that counsel, I think the answer to Judge Richardson's question implies this. Assume your client didn't pay the fee ultimately in time. Would you still say it was commenced when it was delivered initially?
Absolutely, Your Honor, I do. I think in that case, there may be another reason to dismiss the case. I think Rule 41B would provide for that, or potentially it could be Rule 11 sanction. But I think the case would have been commenced at that point. And I think that because that's what the federal rules say. I mean, Federal Rule 3 says a civil action is commenced by the filing of a complaint. And Federal Rule 5 says that a paper not filed electronically is filed by delivering it to the clerk. That's exactly what my client did under anybody's understanding of the facts in this case.
So if he had just filed, I know counterfactually, imagine that he had just filed an IFP motion, no complaint. That doesn't commence an action, right?
That's correct, Your Honor. Yes, what has to be with the court is the complaint. And it's really, I mean, I don't want to be a broken record, but it's the text of the rules. And I don't think there's anything else that I've seen.
Can I ask about this proposed complaint thing that seemed to trip up the district court? Is that because of some local rule or practice in this court that technically it's stamped or filed as a proposed complaint rather than, why are we calling it a proposed complaint? Did your client call it a proposed complaint?
No, Your Honor, he did not. I don't know why it was called a proposed complaint. You can see that if you look at the complaints in the record at JA 15 and JA 133. Those are the two complaints. They are captioned complaint. Everything in there, a fully formed complaint. Indeed, if you flip to page JA 38 and JA 44, you'll see the filed complaints. It's the same document, exactly. Only difference
like
is stamp.
It's almost like a motion to amend setting. When you're filing a motion to amend, you attach your amended complaint, and it's kind of called proposed until the motion's granted.
That may be the analogy that the court was thinking of there. And of course, that would run differently, might run differently because you've got to get permission in most cases to amend your complaint. I still think it's filed, but I don't think it's.
So the view then is, look, regardless of whether this district court deems things a proposed complaint until IFP is granted, Rule 3 says what Rule 3 says.
That's right, John. I do think it's the answer is most consistent as well with the most analogous Supreme Court precedent. And I know that Your Honor was not looking for policy decisions, but it happens to be happily the one that's most consonant with fairness.
The precedent you're referring to is Parisi?
Yes, sir. Happy to address any questions before the court, but if not, I'll ask the court to reverse and remand this case for my client to have his day in court.
Thank you, Ms. Ellis. Ms. McCudden, we're happy to hear from you.
Thank you, Your Honors, and may it please the court. The district court properly concluded that the statute of limitations should not have been told in this case. And it's based on the specific facts of this case and the defendant's, or excuse me, Mr. Allen's unclean hands in the way that he went about bringing his complaint before this court. Mr. Allen filed his—
Well, you might be right that if we're in a tolling world, the district court didn't abuse its discretion in declining to be tolling. But I take your friend on the other side's primary argument to be there's no tolling, which is to say, you know, you heard Rule 3 plus Rule 5, this complaint was filed within the limitations period, irrespective of tolling. So we don't need to decide whether tolling applies.
Sure, but I think we also have to look at the language of the statute. And if you look at the IFP statute itself, it says that any court of the United States may authorize the commencement, prosecution, or defense of any suit, action, proceeding, or criminal without the prepayment of fees. And at least the Seventh Circuit, for example, has concluded that based on that language of the statute, when it's read in connection with Federal Rule of Civil Procedure 3 and 5, as my opponent cited, says that this statute actually creates an exception to that general rule. And if you read the language of the case of the Seventh Circuit in Williams-Judice versus Board of Education, the courts reached that conclusion. And the other thing that I'd like to—
Why do we understand that as an exception as opposed to an authorization? Right? It gives district courts the power to do something.
Correct.
Right? That doesn't naturally read into an exception to Rules 3 and 5.
I suppose it authorizes the court to use its discretion to not just plainly read Rules 3 and 5, and to also look at the statute and use their discretion, if they so choose, to look at the statute.
So I totally get that. So you take this. So What that seems to me is it gives them the authority to say, no, I will not authorize this without a fee, right?
Right.
Or I will authorize it without a fee. So they totally have that authority. But why does that change the words in 3 and 5, right? It's giving the district court some authority, right? It's not creating an exception to 3. I don't read it as an exception to 3 or 5. Help me understand how I get from a grant of authority to the district court, right?
Right.
To an exception to 3 and 5, which don't deal with fees themselves.
Well, I think that when you read 3 and 5 together with the statute, the conclusion, which was the conclusion reached by the 7th Circuit, is that it authorizes the court to say that a complaint is not filed until the prepayment of fees. And the court here at the district court
So wait,
level,
the IFP statute authorizes district courts to make an exception to Federal Rule of Civil Procedure 3?
no, what I'm saying is it authorizes, the statute authorizes the court to say that a complaint is not filed when an IFP motion is brought before the court until the application is either ruled on or the fees are paid. And in this case,
well, then what do we say about Parisi in that? I mean, what do we say about, so there's a question about whether the action's really commenced until, so let me take a step back. So Parisi says the notice of appeal is filed when it's filed, regardless of the fact that there's also a statute that says you have to pay a fee to file a notice of appeal. Now, I guess you could, so let me take one step from that. One step from that to say is, okay, well, let's ignore IFP for a moment. Let's just talk about regular civil litigation where you pay the final fee. I think given Parisi, it would be hard to argue that the same is not true for commencing an action in district court. That is to say, again, ignore IFP. There's a rule that says if you want to commence a civil action, you have to pay a filing fee to commence a civil action. I think given Parisi, it would be extraordinarily hard to argue that a plaintiff who files a complaint but doesn't pay the filing fee hasn't commenced an action. Would you agree with that?
well, I think the action commences when the court either decides to grant the IFP motion.
No. This is not a defendant. This is just a defendant. This is just a defendant who screwed up and forgot to pay the filing fee. They're not asking for IFP status. They're ExxonMobil. They have no plausible claim to IFP status. They just literally forgot to pay the filing fee. But I think under Parisi, the action is still commenced when now the district court could issue order to show cause why should not dismiss your complaint for failure to pay the filing fee. But the complaint is still filed and the action is still commenced, right?
I agree, Your Honor. But under the facts of this case, we have a fundamental issue with Mr. Allen's conduct in connection with the misrepresentations that he made.
But none of that matters if the action was commenced. None of this matters until we're into equity land, and we're still debating whether we get into equity land at all.
Well, Your Honor, one of the things that my adversary pointed out is he says that the majority of the circuits have this view that the complaint is deemed filed as a matter of law when it's filed with the IFP motion. And one of the things that I think it's important for the courts to look at is it's in Williams-Judice, it's in Truitt versus County of Wayne, it's in Jarrett versus Sprint. The Ninth Circuit also looked at it in Escobedo versus Applebee's. The Third Circuit also looked at the concept in McDowell versus State, and the Fifth Circuit also looked at it in Hernandez versus Aldridge. And they're making all of the decisions that they make. They look at, in addition to the rules of federal procedure, they make comments about the conduct of the plaintiff. For example, in McDowell versus State, the court, in reaching its conclusion that the complaint was deemed filed not when the IFP motion was ruled upon, but when it was initially filed, it says, however, there is no evidence that the plaintiff acted in bad faith. Similarly, in Escobedo, in making its decision, the Escobedo court says Escobedo delivered her complaint in a timely manner, accompanied by an IFP application submitted in good faith, but found herself barred from access to the court, and the language goes on. Similarly, in Hernandez versus Aldridge, in making the ruling that it does, the court also says in its conclusion, it says the court therefore determines in light of the circumstances of this case, the complaint was timely filed. And so I think that we do have the rules of court and the federal rules of civil procedure, which have to be taken seriously. But when you look at the other language in the cases that Mr. Allen's counsel relies on, there's also this analysis about the plaintiff's conduct. And so I think that
Can I just take a step back and with asking my presiding colleague for his indulgence, what possible sense would it possibly make to make the timeliness of a lawsuit depend on how quickly a district court rules on an IFP motion?
Well, I want to make your honor clear. So our position is that when the IFP motion is filed, the timing should toll during the period. So we're not saying that the statute of limitations should run between the time that the motion has been filed and the time that the court.
Well, no, but again, but it does still, because imagine if I had filed, imagine there's a 2-year statute of limitations and I file on day 1 of the 2-year statute of limitations. As long as the district court doesn't literally take 2 years to rule on my IFP motion, we never have to worry about tolling, because even if the district court bounces me, I can just refile, right? I can just refile within that 2 years. So the only time it matters is when the complaint is filed within the statute of limitations and the district court doesn't resolve the IFP motion until the statute of limitations had expired. And then we have to do this equitable balancing test. What possible sense does that make in deciding whether when a lawsuit started?
Well, Your Honor, I think that the circumstances that we have here are unique in the sense that there was evidence below that the plaintiff misrepresented the date that he received the notice of right to sue in order to extend the period of time that he would have had for his statute of limitations to file his complaint.
Well, if you can prove that, you might have a valid statute of limitations defense.
And you might have other sanctions things. I mean, misrepresentations have lots of consequences, right? I mean, they don't just, that Rule 37's in play. I mean, district courts have a great deal of latitude to, encourage and discourage conduct based on, the sanctions authority to them. And I think, the things that are talked about may be serious and they may give the district court some stuff. It just doesn't, it seems like separate issues from when the case is commenced. I mean, it was either commenced or it wasn't. And otherwise we're always in some, wow, did I do enough bad stuff? Is that going to come back? Okay, how bad is too bad to determine whether it's commenced? Those just seems like, ships that should pass in the night and be different ships.
And there was an application for sanctions that was also brought before the district court. And for whatever reason, this was the route that was taken. But I think that the key for the court to think about in this case is that while the district court might have taken the wrong route to reach the conclusion that it did, the result was correct based on Mr. Allen's underlying conduct.
Yeah, but if we were to decide a case on that basis, we'd be setting a rule for all litigation, that comes before us. And, just say, it's okay to tie the filing fee to conduct, just because you could have done it under a separate rule of civil procedure. That seems kind of, not the way we would be making the best law.
Well, perhaps, but other circuits have in their decisions respectfully, and I pointed that out, have looked at conduct as an issue. And so I think that this court could choose to also follow the decisions of the other circuits that have looked at conduct, particularly here when we have someone who filed a complaint misrepresenting the date that he received the notice of right to sue. There was a whole motion to dismiss his complaint based upon that. He doesn't do anything to alert the court about that. Then he's deposed. He admits under oath that he provided the wrong date in his complaint. He provided the wrong date in his answers to interrogatories. And he still doesn't do anything to alert the court after there's already a decision that the court issued saying, hey, I'm going to let this play out in discovery and see what happens. There's a duty to have candor. And just because he's a pro se, that doesn't necessarily mean that the court should excuse that. And so for those reasons, I think that the court did reach the right conclusion in this case. And unless the court has any further questions.
Thank you, counsel. Mr. Ellis, can you start with your colleague's argument, and you might say Judge Easterbrook's argument about 1915 and how it creates, in essence, an exception, so that if this was a pay case, 3 and 5 totally govern, but because of the authority granted in 1915A, you can't commence an action without the blessing of the court.
Absolutely, Your Honor. I think 4 reasons why 1915A should not be read that way. The first, I think, is just not clear enough to overcome the very clear text of Rules 3 and 5 of the federal rules. The second is that 1914 is actually is the provision that imposes the fee requirement. We read that provision to make the paying of a fee a condition subsequent, not precedent to commencing a suit. The third is that we think 1914C clarifies any ambiguity in 1914A by authorizing a district court to require the prepayment of fees, an authorization that the district court in the Eastern District has not taken advantage of. And fourth, I think it'd be hard to read 1915A to impose that requirement in light of 1915E that requires district courts to dismiss a case, an IFP case, at any time if it finds that it fails to state a claim or is frivolous. Courts regularly in this circuit and other circuits dismiss those IFP cases on those grounds without ever ruling on an IFP motion.
Hard to dismiss something that hasn't been filed.
Very, very puzzling.
But isn't that just the congressional, congressional ordering of decision making, right? Sort of it's like a congressional version of Steel Co., right? You don't have to do this before you do that, right? I mean, Congress maybe has that authority. We can maybe debate that or not, but
maybe they don't. It would be a puzzling thing to dismiss with prejudice a suit that hasn't been commenced. And if Your Honor would brings up Steel Co., if that statute of limitations is jurisdictional, it would be barred by Steel Co. to do that. And I apologize. Actually,
it's not jurisdictional here, right?
It's not jurisdictional here. No, Your Honor. I'm just saying, it sometimes is jurisdictional, and 1915 doesn't make an exception for one way or the other. And if I could, one final point, I think it would be a bit perverse to read 1915A to create a uniquely disadvantaged IFP petitioners in how they timely commence their claim.
It would be a unique disadvantage because a party that was trying to commence a paid lawsuit could just screw up and not attach the filing fee and they'd be fine.
Absolutely, Your Honor. I think that Parisi suggests that very strongly, as you suggested, and I heard my friend concede that point.
But that's the perversity. The perversity.
That's the perversity. Yes.
Thank you, counsel. We very much appreciate your assistance with the case as well, Ms. McCudden. As you both well know, we would love to come down and greet you and say hello in person. We certainly hope that we'll return to that tradition and get a chance to be with you in person before too long. But thank you for the day. And Madam Clerk, if you would adjourn us for the day.
Judge. This honorable court stands adjourned. Sign and die. God save the United States and this honorable court.